KLE Society's Law College, Bengaluru.
वीरभद्राय अग्निनेत्राय घोरसंहारः सकललोकाय सर्वभूताय सत्यसाक्षात्कारः शम्भो शम्भो शङ्करा ॐ शिवोऽहं रुद्रनामं भजेऽहं भजेऽहं रुद्रनामं भजेऽहम् ब्रह्माण्डकोटि अखिल परिपालना पूर्णा जगत्कारणा सत्यदेव देव प्रिया वेद वेदांत सारा यज्ञ यज्ञोमया दुष्टरा दुष्ट निग्रह सप्तलोक संरक्षणा सोम सूर्याग्निलोचना श्वेत ऋषभ वाहना शूलपाणि भुजगभूषणा त्रिपुरना समर्थना व्योमकेश महासेन जनक पंचवक्त्र परशुहस्तनमा शिवोऽहं शिवोऽहं रुद्रनामं भजेऽहं भजेऽहं ॐ शिवोऽहं शिवोऽहं रुद्रनामं भजेऽहं भजेऽहं
Thank you so much. Thank you. If you all is difficult, I know, to go with to spiritual. My final year, Teja and Simran. Teja and Simran.
You should have విఘ్నరాజ వినాయక నిన్ను వినామృచుట వినాయక నిన్ను వినామృచుట अनाथरक्षक अनाथरक्षक निवेदाता अनाथरक्षक निवेदाता आदरिंपरनु ब्रूमराध विनायका निन्नु विनामृचुटतु विनामृचुटतु. Thank you.
Thank you, Nidhi. That was delightful. Now we have Chandrupa ma'am for the introduction of a society is revealed in how it treats its children, said Nelson Mandela. Good morning, everyone. Today we have gathered here to discuss and know more about the POCSO Act of 2012. This Act of 2012 and its corresponding rules were enacted with the objective of protecting children from a slew of sexual offences and introducing child-friendly judicial mechanisms for dealing with such offences. Yet, despite the existence of the scale of such abuse is staggering. According to 2017 survey conducted by World Vision India, 1 in every 2 children is authorities for redressal. Incidents of child abuse have increased exponentially as a recent study demonstrates that general level of awareness of the POCSO Act remains woefully inadequate in our country. A few key things to know: it is a gender neutral law. So it defines child as any person below the age of 18. So it sets the reporting obligations are given under section 19 of this act. It requires every person who suspects or has or special juvenile police unit, and failure to do so calls for imprisonment. There is much more to this act, and to know more about the POCSO Act, let's officially start our program and welcome our guest speaker. Working as a civil judge junior division at Dandeli, Kumata, promoted as senior civil judge in the year 2017 and worked at Nawalganj and Dharwad. We welcome you, sir.
Not elaborate on that, but let me just say a few words and request my guest of the day to deliver a lecture on POCSO. Children as a class in the society has been given a special status under the Constitution of India. If you glance through the provisions of the Constitution of India, in various provisions you find a reference to children, starting from Article 15 Clause 3, Article 24, Article 21A, Article 39, Article 47. So you can even fundamental duties, Article 51K. So there is a special mention of the children, means the constitution makers were well aware about the special need of the children as a class. So many protection or many rights have been provided under the constitution. Till date, there have been many enactments. It's not that there were no laws to protect the interest of the children in India, but they were falling short of, or they were taking care of the well-being of the children as such, but their abuse as such was not addressed properly. So in order to deal with this abuse of children, especially the sexual abuse of children, was a menace that is a menace that is increasing in India, unfortunately. So in order to deal with that, this legislative piece has been enacted by the Parliament, and we as a law students and law teachers will study it as a law and a theory part of it, but the resource person of the day will be able to give us the practical aspect of it, because they see that law in action in the courtroom and when trials are being conducted. So I hope this event will be useful for all the students as well as faculty members to know the nuances of the practical aspects of the POCSO Act. With this, I end my talk. Thank you.
Yes, sir. Respected all the lecturers of this institution, my dear students, today the topic assigned to me is a POCSO Act 2012. sexual offences. So there is no specific provisions or the laws dealing with sexual abuse of male children. In that intent, it has been mentioned in the Act. I will not detailedly go through all the sections. Important section I will tell. As per section 19 of the POSCO Act, reporting of offences to the special juvenile police unit is there. If ever any offences has been committed, then we should report before the special juvenile police unit is there in the district, or to the local police we can inform the same. At the same time, under section 19 bracket 5 of the POSCO Act, in case the child is in need of care and protection, then SJPU or the local police to provide such care within 24 hours of the report. If that child is in need of any care and protection, then assistance has to be made by the SJPU and the local police. And under section 19(6) of the said Act, the local police to report the matter to child welfare committees there in every district. Then they have to report the same before the child welfare committee, and special court which was designated in every district, courts which is headed by the additional district judges within 24 hours. Means in this POSCO Act, the time limit has been given for every act. The person from the cadre of police, even the judges, even the public, even the informant, all are responsible and they have to maintain the time. For the reason that we have to protect the children and we have to protect their and we have to care them. Otherwise, the mental status of a particular child will go down. At the same time, failure to report the same means if ever any such offence committed in front of you, and as a responsible citizen, if you fail to report the same, then as per section 21(2), the imprisonment of 1 year and also fine can be imposed by the court, and police can lodge or register a case against a person who has not informed the action or the offence committed in front of you, or the person who has not informed the same to the local police. And under section 21(3), if any offence committed in front of a child and the child has not informed the same to the local police, then as per section 21(3), failure to report by a child to the local police is not punishable because they are protected under that. Next, the obligation of the media or the studio and the photographic facility report under section 20 of the Act, which has to be made, and also under section 21(1) of the Act, which clearly explains that failure to report commission of an offence is punishable with imprisonment of 6 months or with fine or both. Next, under section 23 of the Act, which explains that media persons not to disclose the identity of the child except when permitted by the special court. If they want to disclose the child, then the special permission from the special court is a must. If without taking any such permission, if any report they publish about the identity of a child, then it is also punishable under the Act. This school name, neighborhood name, and also other particulars which lead to this act or the offence is committed against a particular child, if it is reported in a paper or published in a paper stating that a such and such particular girl is subjected to sexual harassment, it definitely amounts an offence. if he discloses any identity of the particular child. Then as per section 22 bracket 1 of the Act, if any false complaint against any person with malicious intent is filed, then it is also punishable with imprisonment of 6 months or with fine or both. Next, we will come to recording of statement of a particular child. If any offence is committed, then as per section 24 of the Act, it is the duty of investigation officer. He has to take the child before the judicial magistrate for the purpose of recording the statement, and he has to create a child friendly atmosphere at the time of recording the evidence. Because as all of you know, at the one time, because of that sexual harassment, the mental stability of the child already will go down. At the same time, if you are not creating any child friendly atmosphere to the particular child, then definitely they will not speak truth. Okay. So for that reason, under section 24 it is provided that the recording of statement can be made at the residence of the child itself. We have to we have to visit the house of a particular child, and there we have to record the statement. And also at the time of recording the statement, officer not below the rank of sub-inspector has to record the same. At the same time, the police officer not to be in a uniform at the time of recording the statement, because the child will afraid by seeing the uniform and all. Then child not to come in contact with the accused. At any point of time, the face of the accused should not be shown to the child, and at the same time the child not to be detained in police station in the night. If ever any offence is committed and you are taking that child to the police station, and in the police station they made them that child to sit in the night and all, then definitely the morale of that child will go down. So the protection is given under section 24 for all these things. Next, as per section 25 of the Act, recording of statement by the magistrate has to record the statement, and it is very confidential. So in so many cases, in front of me also, the child was produced for recording statement, and it is a horrible situation for us also, because sometimes they are not in a position to say what to transpire before a magistrate, because out of that shock only they will not come out at that time. So we have to take that issue very seriously. If ever anything happen to the child who in our house, then what will the situation of a particular parent is the question. Then how we should act in the society, and how we have to protect that child is the question. So till any problem comes to our children, we won't wake up. It is only when our children come in contact with particular crime and all, then we will raise the voice. But how brutally they have killed that Nirbhaya. After that, so many changes have been brought out to the Act in IPC, CRPC, in CRPC, and also in POSCO Act. Stringent punishment has been provided, and amendment has been made. As per section 164 of Criminal Procedure Code, a particular procedure has been given for recording the statement of a particular child, and the statement, at the time of recording the statement, what that child says, the same word has to be transpired in the particular statement. And at the time of recording the statement also, the presence of police is prohibited. Only the person, the guardian of a particular child, parents, or the child with whom she is having trust, that person can be allowed at the time of recording the statement. And it is also recorded in the closed room, for the reason that she should not afraid of seeing others, and advocates are not allowed at the time of recording the statement. Next, if ever in Bangalore and all, the children from Bihar, children from Tamil Nadu, Andhra Pradesh, they will be produced before the particular judge. At that time, the judge may not know about the Tamil or other languages. So at that time, as per section 26(2) of the Act, a translator can be appointed by the court. Next, and another point has been point has to be noted that whenever possible, at the time of recording the statement, audio video electronic, by audio video electronic means we can record the same. Earlier it was not there, but now we can record the statement of the particular child by audio video electronic means. After the commission of the offence, if the child produced before any doctor for the examination of the particular child, then as far as possible, it is by the lady doctor who has to examine particular child. Then that the medical examination shall be made in the presence of parents only. And also, in case of parents of the child cannot be present, then the medical examination to be conducted in the presence of a woman nominated by the head of the medical institution. If the child is subjected to sexual assault, then if she is not having any parents or guardian, then at the time of medical examination, the head of the medical institute, he has to nominate one woman at the time of medical examination. Next, after examination of that child, report shall be sent to the investigation officer, for the reason that they have to file final charge sheet against the accused, or it will be helpful for them at the time of investigation. Next, as per section 28 of the Act, a court of session in each district to be designated as a special court for the speedy trial. Now, in our Karnataka also, so many POSCO cases are pending in a courts. In some cases, what will happen means, after registration of that case and all, at the time of trial, that victim come before the court and she turns hostile to the prosecution case. So in so many POSCO cases, the conviction rate is less, for the reason that the victim will not support, or in some of the cases the parents of the victim will receive money from the accused for giving false evidence before the court. For that reason, the rate of conviction is less in India. So we have to improve that mechanism in order to give more conviction, because if the rate of conviction is reduced means the offence will increase definitely. And another thing, as per section 33 of the Act, the identity of the child not to be disclosed, trial should be conducted in camera, and also child not to see the accused at the time of testifying the accused. It means at the time of trial before the court, the proceeding shall be made in camera. The presence of accused advocate, presence of accused, and presence of one bench clerk, typist and the judge is allowed. Now, in our entire Karnataka, in all courts, in special courts, child-friendly courts have been established, where a separate barricade was made in front of the court, in which the face of the accused not clearly depicting to the child, and in front of the court itself one sofa set has been made for the purpose of sitting that child. It means at the time of recording the evidence a friendly atmosphere has to be created, otherwise the child won't speak anything against the accused. Next, at the time of trial also, before the court, a frequent break has to be given to the child, because of that incident. Whenever they give evidence before the court, they are not in a position to give evidence monotonously. For that reason, frequent breaks has to be given by the court. Next, at the time of recording the evidence, the presence of parents or guardians are allowed. Next, the child not to call repeatedly before the court for testifying the same. Means, if the child is appearing before the court today, means the cross examination, chief examination as far as possible has to be completed today only. Next, now we have to see what were the offences covered under POSCO Act. Under section 5, aggravated penetrative sexual assault. Under section 7, sexual assault. Next, section 9, aggravated sexual assault. Section 11, sexual harassment of the child. Now we have to see what is aggravated. Aggravated means when child is below 12 years of age, if any offence is committed against a child below 12 years age, and when offender is relative of the child. One thing we have to bear in mind, that most of the offences are committed within the house only. In Bihar, even in Karnataka also, most of the cases are not reported before the police or the court. When the attempt is also made to murder the child, in so many cases we have seen, after having sexual intercourse with a particular child, they pour acid on the face of the child and they will burn that child by pouring kerosene, and they are putting some nails inside the vagina. I can't explain also. Next, when offence is committed and the child is made or paired naked in the public, after committing the rape, they will throw nakedly in the public. There all incidents comes under aggravated format. Next, when the offence is committed by a person who has been previously convicted, if a particular offender has already been convicted, and once again if he commits the same or the other offence, then it will come under aggravated offence. Then when offence is committed in the course of communal violence, in some places we will see communal violence will take place. At that time some persons will commit rape upon a minor girls, so it will also come under aggravated offence. Next, gang assault. In one case, 3-year-old girl raped by 3 to 4 men. 5-year-old girl raped by 3 to 4 men. Means the mental status of particular accused is very important. What's the mens rea? Why he is doing that? For that, basic things has to be taught in our house itself, from the childhood days only. Otherwise, by seeing every girl, some bad things will come to a particular child. So that has to be curbed from the childhood days only, by giving a good education about sex. In foreign countries, as you all know, they will teach about what about sex and all. But in our India, there is no such mechanism to teach, or there is no lesson in the or there is no subject to the students to learn what is about sex and all. By listening that word itself, we will get some shade. That's the problem in India. For that reason, so many offences are committed in in-house and also in the public. Next, when offence cause grievous hurt, and when offences cause physical and mental disability. And another thing, any offence committed by a person in position of trust. If a child is admitted to a particular hostel and that child is under the care and custody of that warden, and if any such offence committed by that warden, it will become under aggravated offence. Next, any offence committed by a person in management or staff, means in colleges, education institution, medical or religious institution, and also in any offence committed in management or staff of jail. If any offence is committed in remand home, JJ home, protection home, observation home, then also that offence comes under aggravated offence. First onus clause. It means the presumption not only violates the fair procedure established by the law, but also violates the right to fair trial. Means to prove that he is innocent. In all other cases, the burden is upon the prosecution to prove the case against the accused. But in POSCO Act, the burden is upon the accused to prove that he is innocent. The Protection of Children from Sexual Offences Act only applicable to child survivors and adult offenders. In case of two children means below the age of 18, if they have sexual relationship with each other, then Juvenile Justice Care and Protection Act 2000 will apply. Next, in 2019, amendment to POSCO Act has also made, in which the minimum punishment for aggravated and penetrative sexual assault on children below 16 years was increased from 10 to 20 years, and which is extendable to life imprisonment or death. And POSCO Act, as you all know, came with effect from November 14, 2012, along with the rules. And all the offences under POSCO Act is non-bailable in nature. And how to register the complaint when the offence is committed against a child? One official portal of National Commission for Protection of Child Rights is there, in which POSCO e-box is there. We have to click that button, which is on the home page of the portal, and then we have to lodge complaint if ever any such sexual offences committed against the child. Under POSCO Act, there are 9 chapters and 46 sections were there. Next, as per the judgment of the Supreme Court, the identity of the child not to be disclosed in the public, and also if any child who come before the court and give hostile evidence against the prosecution, then the prosecutor is having right to cross-examine that child. That has been reserved in the Act. In any case, if the case is registered and at the time of trial, if the court comes to the conclusion that the accused has committed the offence, then as per Karnataka Victim Compensation Act 2011, the compensation has to be awarded to a particular victim. As per General Circular 13/20 of Honorable High Court of Karnataka, it is the onerous duty of the particular POSCO court or the special court to determine the particular compensation amount and then for forwardal of the same for disbursement of the amount. In case if any aspects we have to bear in mind whenever you will you visit a particular village, at that time if you may make any survey, a definite of POSCO cases, but that POSCO cases are not reported before the particular police only for the reason that the said act was committed by father, brother, father-in-law, son-in-law. So for that reason that cases are not reported before the station. So it is our endeavor that we should survey the same. If ever any such cases come to your mind or at the time of survey you will get that case, definitely you can inform the same before the district legal service authority, and through district legal service authority we can make arrangement for filing a case against a particular person who has committed the offence. In Bangalore rural district we are having 5 taluka: Nelamangala, Anekal, Todabalapura, Hoskote, in which we have established one taluka legal service committee where we are having one chairman who is a senior civil judge and we are having member secretary who is a civil judge. They are heading that TLSA. There also you can report the same if any such cases are not reported. And you can also inform a particular villages that a compensation can also be awarded in a particular case, and they can get compensation amount from the court. In so many cases the particular parents are not knowing that compensation will be awarded by the particular court, and in one case what happened means the case has been filed only for the reason that they have to get compensation amount. The parents have filed case against a particular person stating that that person has raped or minor girl only for the reason to extract money from the accused and also from the court. So on the one part benefits are there, on the one part misuse also is there. So it is the burden of the court or the look after of the court at the time of dealing with the case, which is the false case and which is the true case. We have to analyze it. So by this I will conclude my presentation, because only by practical things we can learn. Whatever we discuss now, it will not be useful, because if you get any case of POSCO case at that time, please see that as an advocate whether we have to assist the accused or we have to assist the child who has been subjected for priority. But as an advocate, it is your duty also to protect the accused, because you are working for that, and in the days to come you will go to field of advocacy. At that time, if any such cases comes to you, please help the child who is in need, and in any 10 case, please take one case of POSCO case in order to help the children. So by this I thank our Dr. Sir and also Mohan Sir and also Manoj Sir and also Mantesh Sir for giving me opportunity, for giving some inputs to you. Because of my busy schedule, it is also not possible for me to stay more time here. Already 12:30 is there. So many people are waiting for me there to give some legal assistance. So that is also important. Thank you very much. I hope you all help children in days to come. Thank you very much. Thank you, Vanijya.
Your knowledge with us and your time as well. So now we're open to questions.
Consent in India right now is 18. So many activists are of the opinion that children below age 18 who have consensual sex are being prosecuted under this law, and this is kind of acting as a deterrence for these people. Like I would like to point out, they point out that POCSO Act does not take into account teenage children's sexuality, and they argue for lowering the age of consent in India to 16.
It's already been for the reason of reducing the age of an offender. Okay, it is only that discussion has been held. Okay, but so many persons are opposing for it. They are telling that 18 is the correct age.
Yeah, in Western countries we do have less.
But we can't discuss the same thing now because it's a policy matter and it is before the Lok Sabha and Rajya Sabha. We can't discuss about this.
Okay, thank you, sir.
I can't give any opinion also.
Cases in a court. And my second question is with respect to the cyber related crimes, because now according to the report 95% of the teens are using the smartphones, and 45% of the kids are online. Under these circumstances, how we can handle these type of the cases?
POSCO Act, if any victim who wants to appoint any advocate, then from our district legal service authority only we are appointing a panel advocate to assist the victim, even though a public prosecutor is appointed by the government. One point. And another is a private advocate can also be appointed along with what we public prosecutor, along with the public prosecutor. But under Act itself, the district legal service authority is having power to appoint a panel advocate. Who is the private advocate itself? Act itself says as per section 40. Along with the public prosecutor, a private advocate means panel advocate we are appointing now also. That option is there. That option is there. And with respect to the cyber crime is concerned, one overriding effect has been given under POSCO Act, that for example, if the offence is booked under POSCO Act and SC/ST Act or any IPC or cyber crime, then POSCO Act will prevail. So whatever the offence committed under Cyber Act or ITI, whatever it may be, if the offence is under POSCO Act, then all other act merge with the POSCO Act. Yes.
Present here, it's a great privilege to propose the vote of thanks for this event to all the dignitaries assembled here. I would like to thank our chief guest, Honorable Judge Sir Sandeep Salian, who honored this program with his insightful thoughts. I request Manoj Kumar V. Hiramat sir to give saplings as a token of respect. I would like to Academic Coordinator Dr. Anita MJ ma'am, and I extend my heartfelt thanks to all the teachers, student coordinators. Thank you all. Have a good day.